that we have to avoid. I said these days there are a lot of pitfalls that we have to avoid in arbitration. What I call banana peels sometimes and guerrilla tactics that people do in arbitration, especially maybe a party who doesn't really want to go forward. And sometimes it's just out of error, from one party. So it's very important that we have webinars like this, not only for young members, but for everybody. We keep trying to sharpen our axe more and more and more. And I see this as one of the ways of sharpening our axe in arbitration so that we can be the best. You've got some really good speakers here, and I encourage everybody to stay to the end. I will join as soon as I can, but Mr. Ewale from Alukwano Yebode, thank you for moderating. I know you are going to moderate well. I know you. And Femena, my dear brother, all the way from London via Switzerland, you're welcome. Michael from Olaniwa Ajayi, all these are big players in the arbitration space. Thank you very much for giving your time. Mary and I, we did an ICC course last year. Took us over, I think, 4 countries, but very enriching. We learned a lot, So everybody here is what we'll call my person. And thank you again, Bisoye. And, we have to, I wish I could, I'm going to join as quickly as possible because avoiding these pitfalls is very important for each and every one of us. I am still going to go over the recording and go through it again because everybody, every speaker here, even the moderator, there are people who know the pitfalls. They know the places you should not put your foot in. So if you miss it, if you miss a little bit, the network is not very good, please go back. It's on the YouTube of the Institute. Go back and listen to it again. All the people we're going to listen today, they're the best. So thank you for putting this together. And I'm sure we will all learn a lot, build capacity more and more, and continue to get better. Thank you very much.
Well done. Thank you so much, Ma. We really appreciate your kind words. So to hand over to the moderator, like Madam Chair has already said, is a very seasoned lawyer. His name is Boyega Oyewole. He's a senior associate at Alukwano Yebode with nearly a decade experience, specializing in international arbitration and commercial litigation. His expertise spans multi-jurisdictional commercial arbitration under ICC LCI rules, as well as both contract-based and treaty-based investor-state disputes. He's a member of the Institute, he's a member of the Young Members Group of the Institute, and is very active in the Association of Young Arbitrators, AYA, and ICC, Young ICCA. Notably, he was selected as a member of the 2025-2026 cohort of the Young ICCA Mentorship Program, the 12th cycle. So, I'm handing over to you, Boyega.
Thank you very much for that warm welcome, Abisoye. I must also appreciate Madam Chair for that very warm welcome and encouraging words. We're very conscious of time, and without much ado, we'll dive straight into our discussion. I think the YMG Chair and Madam Chair have set the tone for our conversation today. The essence of the arbitration process ultimately is to have a viable award, which is enforceable. But there's so many things that can derail that process, right? To make you ending up with a worthless piece of paper. And so today we're just going to explore a number of things to ensure that your arbitration process is sound, and also to ensure that the resulting award is enforceable. And I have 3 excellent speakers here with me, 2 of whom I know very well, my brothers, and 1 of whom I've been recently acquainted with, Mary. Without much ado, I'll just ask them to introduce themselves in 2 minutes very quickly. Let's start with Ifemina.
Hi, good afternoon, everyone. My name is Ife Mena, but you can just call me Ife. I'm an associate in the arbitration team at Linklaters in London. But that's not my entire story because many years ago, I used to work in a law firm called Strachan Partners in Nigeria. I did about for about 4 years after qualifying. So I'm very much one of you. My work is in commercial arbitration, investor state arbitration, and public international law. And it's a pleasure to talk to you today.
Great. Mary?
Thank you so much for this opportunity. As mentioned, my name is Mary Mutupa. I'm so excited to be here. First of all, I want to also thank the chairperson for kind regards to us and wishes, and the YMG chair as well, and my colleagues. I'm looking forward to this opportunity this afternoon to share our knowledge and experiences. I'm based in Zambia. I'm the managing partner of ISETO. My experience of arbitration spans over 10 years. I'm getting into my 11th year. So I'm excited to share what I've come across personally, but also what I've heard from others. For more details of really who I am, you can visit my LinkedIn page. Thank you.
Excellent. Mitchell?
Thank you very much, Grega. It's a very difficult act to follow these two luminous individuals, but I'll try. My name is Michelle Agatisa. I'm a managing counsel at Olanuaje. I co-lead the arbitration practice. I also have additional responsibility for government business where we shape policy. I've been doing arbitration right from when I did my LLM in 2015. Both domestic arbitration as well as international arbitration on having dealt with most of the institutions and having familiarity with many of the rules. It's a pleasure to be here today. Thank you very much, Maria. And I also thank the chair, as well as the YMG chair for this opportunity. Thank you.
Excellent. Now that we have that out of the way, I think we can dive straight into our discussions. I think a good place to start our conversation is to look at the foundations of the arbitration process, which is the arbitration agreement and the appointment of your arbitrators. Ifemena, we've seen all sorts of arbitration clauses. What are your thoughts on pitfalls one may encounter at this phase of the arbitration?
Thanks, Gray. I think that separate from just the phase of drafting the arbitration agreement, I think the arbitration agreement is crucial to avoiding procedural traps and pitfalls in particular, because how you start and how you frame the agreement determines more or less how you're able to combat, the procedure and in fact, what sort of procedures you're going to encounter. And like Boye said, you can't have an arbitration without an arbitration agreement. And the arbitration agreement tells you, the rules you rely on. It tells you what act governs your arbitration. It tells you what sort of procedural cautions are available and are capable of being, utilized. So it really is the foundation. And as you probably know, you could have it in a standalone agreement or in an arbitration clause, and it just determines how the arbitration will be run. In particular, at this phase, at this early stage, you want to have a long-term view of what the arbitration will look like. So you want to look at, the rules that are favorable, that, do not allow any form of like abuse of procedure, and so on and so forth. But I think what is potentially most important at this point is to flag that there are certain errors you can make in the drafting of the arbitration agreement that could torpedo and essentially ruin your entire arbitration. I think this subject is usually discussed. This is usually a subject discussed under the topic of pathological arbitration clauses. I'm sure you must have heard that before. And when people talk about this, they often talk about like the arbitration clause being defective in the sense that an essential term or an essential element of the clause is not necessarily functional. And a fun example would be arbitration clauses that refer to a wrong institution. I think there's one involving the Charters of Arbitrators in particular. It's in the case of, I think, Mekunya and Imokwede, if I remember correctly. But essentially, if you have an arbitration clause that refers to the wrong institution, under Nigerian law, you have a problem already in the sense that if you don't have the right institution, do you even have an arbitration clause in the first place? Is it inoperative? Is it ineffective? And these are things that we don't have a lot of clarity on in terms of the view that the courts would take in Nigeria. And that could really just have you arguing for several years about what your arbitration should look like. So I think the starting point is to make sure that it's clear enough. You have the clear referral to arbitration saying any dispute that arises shall be referred to arbitration. You have the institution clearly named, the correct name spelled out. You have, um, you have basically all the major elements of your arbitration agreement set out, the seat, number of arbitrators, the parties, and all of that. However, the thing to really focus on, and I find this to be more of a contemporary issue, will be cost prohibitive arbitration clauses. Many of you are probably thinking, what does that mean? This just basically refers to arbitration clauses where it's potentially even perfectly drafted, but it's such that you just can't get the arbitration off the road because of your party circumstances. So I'll give you an example. I know many of you must have come across, people encouraging you to put arbitration agreements in every single agreement you come across. They never really tell you to make sure you tailor the arbitration agreement to the agreements you're drafting. And you can imagine a situation where you're drafting a tenancy agreement, the rent is 500,000 naira, maybe 1 million, and you put in three arbitrators and you put in ICC arbitration. And now you have a big problem because, first of all, three arbitrators will definitely charge you more than the 1 million naira rent. That's the starting point. But beyond that, you might not know this, but ICC arbitration requires you to pay 5,000 United States dollars to file the arbitration. Now, in a circumstance where you have to pay 5K USD to just file the arbitration, when the tenancy agreement has a 1 million naira, rent potential liability, you're completely shooting yourself in the foot. So I wouldn't take too much time because I think, it's helpful to get views from other people. But the thing to really think about here is when I'm drafting my arbitration agreement, what loose ends am I leaving for a recalcitrant party to torpedo this arbitration? You know, one thing that tends to happen is that, when you make these mistakes, you have three arbitrators for a very small dispute. You could find somebody who is commercial enough to sort of agree to negotiate and arrive at one arbitrator. However, if I'm the party who's likely to lose the arbitration, I have a very weak case. Why would I agree to negotiate to give you a favorable route to arbitration? Why won't I let you struggle in the courts for 10 years and tire you out before you sort of get to any form of this resolution forum? That being said, the AMA is a brilliant, brilliant piece of legislation that plugs in so many gaps to the arbitration agreement, but it's still important to, um, to make sure your arbitration clause is very well tailored to the arbitration agreement. Or actually, I should say this. It's still important to make sure your arbitration clause is not defective, contains all the right elements of the arbitration clause, being the referral, the institution, if you have one, the seat, the number of arbitrators. But it's even more important to make sure that it's tailored specifically to the transaction you're dealing with and is not impractical or unworkable from a commercial perspective. We'll be happy to take questions down the line, but I hope this sheds some light on how the arbitration agreement helps you avoid procedural pitfalls in general and at the start of the arbitration proceedings.
Thanks so much, Efemina. I agree with you 100%. One prevalent thing, particularly in Nigeria, is this commercial mismatch between the arbitration value itself, right, and the mechanism parties have decided to use. Mary, I don't know, is this prevalent in your jurisdiction as well, or what sort of pitfalls have you come across in your jurisdiction?
Yeah, thank you so much. I think Effie has really laid a very, very good foundation on this issue. And coincidentally, yesterday, I'm just coming from a training in which we were training lawyers and arbitrators and others that are interested who are contract managers in drafting enforceable arbitration clauses. And I just want to pick two things that he mentioned. When you're drafting an arbitration agreement, you need to know what sector of that contract that you're coming up. That is very key because you cannot have a standard arbitration agreement which you can just replicate in every contract under construction, water and sanitation, public health, employment, because these sectors are very different. and they have different dynamics. And hence, if you don't pay attention to what kind of arbitration clause you include in those contracts, can actually trap you and be costly, like he talked about. Of course, even here we have a situation where parties draft arbitration clauses where they've included an institution that doesn't exist, or an institution that existed once and it's no longer in existence, or they will include an institution that actually is not an arbitrary institution. So we have those common things that he talked about. But I just want to say that I think one crucial thing that we introduced as ISETO last year is where we're encouraging people, the way they do financial audits, the way they do organizational evaluations, where they bring in an auditor who comes in and do an organization audit. It is also possible to do audits for contracts that you've signed with service providers, because every year, like in Zambia, I don't know there, you find that laws change, policies change, and therefore you cannot have a contract that you would have signed 20 years ago, and laws have changed over time, and you think that they cannot affect your contract. And I think to really remedy the situation, like my colleague said, you need to adopt the habit of doing contract disputes audits, where you look for gaps of what probably has changed in the law, in the policy, but also in the business sector, because business sectors have really continued evolving. So you cannot continue just holding onto a contract you signed 15 years ago, and when you have a dispute, that's when you want to start running around when you find that you have problems. Sorry, I can talk so much. Let me end here and give my colleague Michi to come in.
Yeah, so Mitchell, I know we practice here together in Lagos, but in your experience, what kinds of pitfalls have you come across at this stage of the arbitration?
Yeah, thanks so much, Greg, and it's very interesting what Ifemina and Mary has mentioned. It's similar to what Femina has said, right? You have situations where the arbitration clause just does not work. However, I think I'll just add some flesh to the aspect that Femina mentioned about the AMA, because you see that Section 7, as well as I believe Section 59, now gives flesh to what otherwise would have been unworkable. So when you fail to designate the institution in local arbitration, it says something along the lines that local arbitral institutions or the court may then serve as the appointing authority. And in similar fashion, when you're dealing with an international arbitration where the seat is Nigeria, it's then the director of ARSICAL who would be the appointing authority. But that then leads me to the most fundamental point, which is the question of the seat and place debate or distinction, which for some reason it appears that it continues to have an enduring argument in arbitral practice, particularly in Nigeria, with a lack of understanding of what those two mean. And everybody's favorite case, P&ID, that was a real issue, because the seat was not effectively designated. And it then became the case as to what happens in respect of the orders that were more or less issued by the Federal High Court during the pendency of the arbitration. And in similar fashion, you have this in English law, you have this all over the world. So I would say that one critical point for counsel to pay attention to is the seat. But they shouldn't just think of it like, oh, Nigeria sounds fancy, Rwanda sounds fancy. They should really interrogate how advanced the arbitral laws there are. And not because I'm Nigerian, I think we have one of the most progressive arbitration statutes at the moment on the continent. So it's a good seat, but the question then becomes whether or not the supervising court will be as administratively effective when they are then called upon to supervise as they should. Thank you.
Excellent stuff, Mitchell. Just to piggy off what you said, I think people usually do take into considerations the administrative system of the courts of the seats, because ultimately that determines how fast whatever post-award proceedings you embark on are concluded. But then let's dive into the meat of our discussion itself, which is the arbitration process, the arbitration proceedings. So Mary, let me ask, having avoided potential pitfalls from drafting and the appointment of our arbitrators, once the arbitration commences, what have you seen and what have you noticed in your experience that are common mistakes that people make procedurally?
Okay. The mistakes that a lot of people make procedurally are so many, and I think we can stay the whole day talking about just maybe at every stage. But what I would try and do is I will select specifically maybe 2 or 3 stages and speak to that. And maybe just a run through. You can actually have these traps at the drafting stage we've talked about, at the case management planning meeting. You can also meet this during the submission of pleadings, even at the hearing, even post-hearing, you can encounter this as well as post-award. And so to just sort of like help the participants that have joined us today, as you know, I think one of the common areas where you find a lot that happens is when we talk about the one of the key principles in arbitration, which is natural justice or due process. As you know, this principle basically speaks to the very fact that parties should be allowed to be heard. That is, to be given a chance to submit their case, argue their case, so that also that gives an opportunity for the adjudicator to be able to make a sound decision based on what has been submitted. But of course, in that whole process that I have talked about of what happens, you find that parties are standing on different positions. And as a result of standing on those different positions, therefore, they can exhibit different strategies to try and make sure that they push for their case. And in most cases, especially in high-stake cases, you find that representatives, as well as their parties, try hard to really do anything possible, every gap they can find within the way an arbitrator is conducting themselves, to the law, to the rules, to really advantage their way in an arbitration. Okay, and this is one of the principles also where really it starts the issue of setting aside an arbitration emanates from. And so one of the things that I will talk about is that you find even at the very fact that there is lack of proper notice. So this is a notice, for instance, at the time that you are initiating the arbitration, the party may be skipped to notify the other party. That's a trap already. That can be used by another party to say, look, in our agreement, we said that you cannot go to arbitration without negotiating, for example, without following pre-steps. If there were pre-steps such as mediation or negotiation, if they were in an agreement, so one party can use that. The other thing related to proper notice, this is where you find that in Zambia, what is common, in some of the parastatal companies, they put that you cannot go to arbitration without notifying the other party. So even when the pre-steps have been undertaken, for instance, for you to be able, at the time that you are initiating an arbitration, you will have to inform the respondent to say that we have failed, now we are initiating arbitration, and this is what we are going to do. So if that part of the notice has not been done, the other party can use it as well. The other common part also where we can really talk about it being a trap is in a situation where one party, as an arbitrator, you have to adopt a certain system. So I'll give an example like when a party submits an application, maybe for clarity of interpretation clarity, or even clarifying guidance that you have given as an arbitrator, it's important to notice how many days you are giving each party when they make an application, and how many days you are giving the other party. because they can actually raise the very fact that, oh, you gave Michi 3 days in which for him to submit the application, and you gave me 2 days in which to respond. So sometimes there are very, very small issues that look like they're very small issues, but they can actually become big. So I'm talking about timelines that you give each party to, for example, make their submissions and respond. The other one that I have come across is the issue of limiting, during hearing, the issue of limiting cross-examination or evidence production to issues of just equal treatment, I think, in terms of how you respond as well, really, really matters, because that can be used to say and indicate to one party that where they start sensing that there's bias on part of the arbitrator. The other one I have come across not too long ago, recently, is with regard to document discovery. Okay, and so this is where, for instance, we're talking about. Okay, that's something that I think we'll talk about more later. But I just want to say that's another area that is becoming very, very common that we need to pay attention to. Whereas I move on to to give my colleagues a chance to talk as well. I want to just these other ones I'll just list them because I think we're running out of time. But also just if you have to be very careful not to really employ ex-party communication. You have to make sure that whatever communication, at every time that you are communicating to one party, you are communicating to the other. So basically maintaining from start, maintaining inter-party communication, because the moment you get, if that or anything, any under circumstance, you get to yourself in a situation where you have to communicate to other party, it's always important to disclose to the other party that you communicated to this other party and this is what you communicated. Because if you do that, then you cover yourself. If you don't, that one and the other party discovers, that can be actually misunderstood. Other issues also related to disclosed and disclosed conflict of interest. In Zambia, we even have case law where this has been adjudicated upon, where an arbitrator went into an arbitration and never disclosed that they actually worked 12 or 20 years ago. They worked with one of the parties, but they were not close, but they just worked in the same institution. So, like I said, procedural traps, they don't come clothed in or printed in red and white or black and white. Basically, it's through conduct. A lot of it. It's through conduct. It's a lot of through actions. Really, I think that's where I'll stop here. I think when I share more, I'll share a few pointers at the end, which can be shared with our participants for them to just have a bit more insight. Thank you very much.
Excellent stuff, Mary. Excellent. In my experience, I have found that a large number of set-aside applications are founded on equal treatment issues, due process issues, fair hearing issues. Efemina, has this been your experience as well?
I mean, on that particular question, you are correct. I'm currently acting in set-aside proceedings and enforcement proceedings in Tanzania, and it's exactly the same questions being asked. I had arbitration in India, it was the same question being asked. You didn't give us enough time, you didn't give us enough, you give us less time than the other party. And that's a big issue that goes into set-aside proceedings, even though, in my experience, courts tend to take those things less seriously, unless, of course, it's a clear case of unfair treatment. But still, it's better to make sure that at the tribunal level, even you as counsel are not trying to take advantage of larger deadlines, rather trying to ensure that everybody has an equal footing to avoid the sort of squibbles and squabbles at the set-aside stage. I think two things to flag. The first one is if the participant listened to Mary speak and when I spoke, you notice that when you're thinking about arbitration and thinking about traps and thinking about the proceedings itself, you have to have a full view of the case from start to finish because we're talking about procedural traps during the arbitration, but our minds are going to set aside proceedings because everything happens in the arbitration will be the basis for set aside proceedings after the case. So you have to sort of think about it from start to finish and have your minds on what are the grounds upon which this award when I get it can be challenged. That's the mindset to think. Whenever an objection is raised in the arbitration, think about all the ground set aside proceedings and think about whether the objection engages any of them and whether you want to take a conciliatory approach or get around that problem by, conceding something that might be a big issue in the arbitration, but a smaller issue in the grand scheme of protecting the award. The second point to flag is a Nigerian specific practice, and it usually happens during the arbitration, but it tends to happen outside of the arbitration, and it's the concept of parallel proceedings and court injunctions. And I know more than one person on this call, even aside the speakers, would have dealt with a case where you have an arbitration on foot and somebody commences proceedings in the High Court or in the Federal High Court touching on the same subject matter and seeking the same relief. Sometimes they even go further to ask the court for an injunction saying, restrain this tribunal from continuing because the arbitration agreement is wrong, is invalid, and so on and so forth. And sometimes our courts fall into the trap of this, applications or proceedings and tend to halt the arbitration proceedings. However, I just want to flag a few concepts that sort of help us get around this problem. And the first one is that the AMA is very clear on what to do when there is a proceeding that touches on the subject matter of an arbitration agreement. And the AMA provides, I think, in Section 5 now that if you apply to state proceedings, the court should state proceedings unless, the arbitration agreement is invalid in some way. And the corresponding doctrine talked about is the doctrine of competence, which is also embodied in the Arbitration Act. I forget the section. I used to be in the old section 12 or 13. And what that doctrine does is that it sort of says the tribunal decides on jurisdiction, and the implication is that therefore, at the stage when the court considers this, the court doesn't have to do a big, look into the validity of the arbitration agreement. The court just has to refer to the arbitration. And thankfully, Nigerian courts tend to take this approach as well. But the one thing to flag also is that in the same provision, I think it's 5 subsection 2, it talks about how the tribunal actually has the power to commence, or rather to continue proceedings. In fact, it says the party can go ahead and commence the arbitration proceedings if it hasn't been commenced. The tribunal can continue it, the tribunal can conclude it, notwithstanding that there is an ongoing court proceeding that touches on the same subject matter. So the Act actually gives you direct leverage to continue the arbitration, even if a court somewhere is dealing with the same matter. Now, this is tricky, and the tribunal will ultimately decide whether to proceed or not. But these are the kind of tools you can put to the tribunal saying, well, in a case where this is clearly brought to an abuse of process and in bad faith, you can actually proceed based on this provision. You can also similarly tell the court, well, Federal High Court, your Lordship, High Court, your Lordship, this provision says we can continue. So therefore, there's no reason to stop this proceedings now when you still get set aside proceedings somewhere in the future. So I just wanted to flag this for anyone who has this issue. There's a similar issue of people trying to challenge procedural orders by the tribunal. But I think the key thing to say there is that if you read the AMA carefully enough, you see that it carves out procedural orders from matters that can be challenged, even though they are decisions of our courts to the contrary. So you do have enough in your arsenal in the AMA to combat this sort of parallel proceeding, injunctive relief, guerrilla tactics.
Thank you so much, Efemina. And Mitchell, any thoughts on the conduct of the arbitration itself?
I think for me, one thing is, look, as it relates to the conduct, Femina and Mary have more or less covered the field. But one important issue that we're beginning to see, which prefaces the arbitration or carries through into the arbitration, is as it relates to conflicts of interest of the arbitrators. And increasingly, it's becoming a situation where oftentimes for lack of diligence on the part of counsel sometimes, and lack of forthrightness on the part of the arbitrators on other times, that then becomes a poison pill that invalidates all the potentially good work that had been done during the arbitration. So for me, I think that it's something that counsel needs to pay attention to. and continue to pay attention to. Because oftentimes it is the case that these are matters that should have been disclosed before the arbitration commenced or at the point where the arbitrator was being selected. And I think as counsel, there are now tools, the IBA list, the red, orange, and all of the nice traffic code colors. But I think counsel should be bold enough to put questions to the arbitrators at the point of appointment. And I think to the extent that resources are available, to continue to conduct periodic reviews of what those arbitrators are putting out there, the work that is being disclosed about them during the course of the arbitration, such that those self-same issues do not create problems in future. And I think for the longest time, it had been the case that, lawyers had only thought about conflicts in the context of arbitrators. But we're increasingly beginning to see material jurisprudence from across the world suggesting that even as it relates to experts, that question is a real issue to consider. So I think that lawyers, beyond everything else they do vis-a-vis the adversarial nature of arbitration, should also be thinking about ensuring that they're not dealing with an arbitrator who, either by lack of forthrightness or just general inadvertence or lack of recollection of what they have done in the past, do not then invalidate what has been done during the arbitration and the investments that have been made relating to counsel fees and the whole arbitration process. That's what I'd add.
Thank you so much, Mitchell. Also, I have you here. Let's talk a bit about what happens after the arbitration. Now,
Sure.
It's one thing to get an award, right? It's another thing entirely to get paid.
Mm-hmm.
What are your thoughts, right, on ensuring you have an enforceable award?
Absolutely. Thanks. For me, I think 4 key things. Number one, interestingly, once upon a time, the long-running joke, and I know Boyega and Femina, you'll be well attuned to this joke, that it appeared as though your arbitration award was just step 1, and then you're to go to the High Court and start litigating over the award. And I think it's the case that the AMA has tried to more or less circumscribe that. Mm-hmm. And we're receiving recent authorities, including from the Supreme Court, in EMTS and AFDIN, where I paraphrase, but the Supreme Court said something along the lines that parties to an arbitration should enjoy the benefits of the award, and more or less discouraging, appeals on, a host of grounds. Now, in Nigeria, I would say Nigeria, then I would thereafter look at what the international practice has been. In Nigeria, it's the case that pre-AMA 2023, the misconduct ground of challenging an award, I would say, was an unruly horse, in the sense that counsel, strategic and very brilliant counsel like Boyega, will identify things that could potentially fit within the elements, right, of misconduct and have a day in court and more or less serve as some form of Italian torpedo to counsel or other parties being able to enjoy the award. Thankfully, the AMA 2023 has tried, I would say, to circumscribe the grounds upon which you can then challenge an award. The question now becomes whether or not this circumscription has carried over to a situation where people have a quicker path to obtaining the benefits of the award. For me, I would say that the jury is still out on that. We need to continue to assess. But one thing that I know is that because of these circumscribed, my apologies, grounds, right, under the AMA, which really are five, whether or not the agreement was invalid, whether parties lacked capacity, whether or not parties were given proper notice or ability to present their case, part of what Mary had mentioned on conduct, whether the award exceeded the scope of the arbitration agreement, whether the tribunal was constituted according to the agreement, and whether or not it is not yet binding, i.e. the award, or it has been otherwise set aside elsewhere. Now, I think what the MA has done is that it has given us a closed box within which to check whether or not we can have this set aside, failing which there should be a clear path, I would say, to obtaining the benefits of the award. We have seen jurisprudence in Nigeria, which, for lack of a softer word, I will call it an aberration on our jurisprudence, whereby in Limac, we had a situation where our courts purportedly thought they could set aside an international award that was not seated in Nigeria. But thankfully, again, it is the case that the jurisprudence in Nigeria, I would say, has moved with the case of Champion Breweries, where they've more or less corrected that wrong. So for me, what I'm seeing in terms of the lay of the land is that the issues that we were having that seem to be the hurdles towards enjoying the benefit of the award appear to be systematically being taken away. However, it is still a question for counsel. And what's that question for counsel? Number one, when you're going into this arbitration, a business or commercial question you should ask yourself in advising your clients, which is not a law question, is what is the capacity of this counterparty to pay? We have an award recently, several millions of USD, and we just realized that this counterparty and his company are what we would term in Nigeria indigents, albeit international. And there's no path to recovery. One. Two, you also need to identify, especially when it's international, if this counterparty has assets and where do they have assets. Oftentimes, we make the mistake of thinking that the New York Convention is applicable everywhere in the world. It is not. There are a host of countries that are not yet signatories to the New York Convention, and that puts a nuance in the advice you give to your clients as it relates to obtainment of the benefits of the award where the obtainment is not within jurisdiction. And third, and most importantly for me, right, is that upon obtainment of the award, it is critical that you do what is most basic. You actually then take the enforcement steps. Oftentimes, we actually think that the work is done and counterparties are just going to say, oh, thank you, you've been so kind, here's your money. But oftentimes, the work then starts. And the work beyond the legal aspects relating to process also includes things like having tracing agents that are able to
Yeah, I think Mitchell is having some network difficulties. And can everyone hear me just to confirm? If you may not, please confirm.
Yeah, I can hear you.
Okay, okay. So once he's gone, Mitchell, can you hear us?
Yes,
Okay,
I
okay,
can hear
you're
you
back.
now.
Okay,
Okay,
please go on.
fantastic. I don't know where you heard me up to, but the last point I mentioned was that it's then important for you to know that the counterparty is not just going to surrender and give you what has been given in reward, but you actually have to then take that step, and beyond taking the actual procedural steps of approaching the court to enforce as written judgment of the High Court, it is critical to also have the other practical elements, including, for example, tracers who are able to identify where assets or cash is located, such that you can then proceed accordingly, including if you need to appoint international counsel in the places where those assets are located, such as to take the enforcement steps within the domestic jurisdiction. So that was it for me.
Thank you very much, Mitchell. Before I take contributions from Ifemina and Mary, I just need to mention that if you have questions, please put them in the chat box, and we would have a very brief Q&A session after the presentations. So please, if you do have any questions, please drop them in the Q&A box. Ifemina, please, what are your thoughts on enforcement generally? What are the things you have seen that either hinder enforcement or in fact render your award unenforceable?
I think much of my experience predates the AMA, so everything I might say might not be as useful, and I think Mitchell has done a fantastic job covering the field. I think I'll just speak briefly about the AMA, which is, futuristic and sort of something I feel very comfortable talking about. And the first thing to say is that once the award is rendered, you have very limited scope for intervention in the sense that you either apply to set aside the award on the limited grounds in the AMA, or as the losing party, you apply to, or you attempt to refuse recognition and enforcement or resist recognition and enforcement when the winning party tries to do so. The AMA has very limited grounds to do both things, set out in, I think, sections 55 for set aside proceedings and a later section for recognition and enforcement proceedings. But the key thing to flag is that all these things are written in very nice text, all in English language, and the scope of the grounds are made very clear, very narrow. But we have a tendency to, in our jurisdiction, in Nigeria and across Africa more generally, to what's it called? To interpret these things in ways that stretch them beyond the intended scope. For example, in Nigeria, I've seen cases where people have argued in the past that public policy includes contravening the duty of fair hearing, and they rely on a separate case that says fair hearing includes failure to properly consider the evidence, and they rely on a separate case to say that if you don't look at the evidence and refer to it in your judgment, then you've not properly considered the evidence, and they make it this whole appeal system. And I think the mechanism I want to point you to really is contained in section 91, subsection 10 of the AMA. And it really is a provision that basically sets out the way and manner in which the AMA should be interpreted. And what this does is that for the Nigerians in the room, if you went through law school, you're probably thinking, well, the rules of statutory interpretation is that you start with the literal rule, then you go to the golden rule, then you go to all the different rules and so on and so forth. But what the AMA does, the AMA says, well, forget all those rules. We have our own internal statutory way of interpreting this AMA. And he says, and I quote, in the interpretation of this act, regard is to be had to its international origin. So therefore, every bit of text you're reading, look at the international origin, and to the need to promote the uniformity in its application and observance and good faith. So basically, we're looking at the international origin of the text of the AMA, and we're trying to make sure that in interpreting the AMA, we're promoting uniformity in how the text from its international origin has been applied, broadly speaking. And it says the court may also have recourse to the travaux préparatoire of the ancestral model law on commercial arbitration, which is the model law on which the AMA is based. And this is important because it means that when you're interpreting the AMA, the fact that a word like venue ordinarily literally means the room where you do the arbitration, you should look at what the word venue in the ancestral model law would have meant, what the word venue or place would mean internationally. What is the common best practice interpretation of that particular word? And that precisely applies even more importantly to the set aside grounds and to the grounds upon which you can resist the recognition and enforcement of an award. So this is sort of something I like to point out quite frequently to assist you in combating broad brush challenges that are not intended by the AMA and are not compatible with arbitration. And what this looks like in practice is actually quite clear from the EMTS decision in the sense that you will now have to look at what other jurisdictions are doing, what's being done in England, what's being done in France, what's being done in the US, what's being done in Singapore, what's being done in the leading arbitration jurisdictions that apply the model law or similar concepts, and how then can we reach a position in Nigeria that promotes uniformity and good faith in the act? Also, the word good faith actually tells you from the go that any challenge that is brought in bad faith already fails the good faith test. So you have these mechanisms to pull on. The second corollary point to flag in a single sentence is that no matter how good your arguments are, it's the court that upholds or rejects them. And I think we need to rely on the courts to do a better job than they're already doing. AMTS was fantastic in the sense that it tells you, out with the old order, in the new order, you can't just challenge on any basis. But we really need courts to be more prescriptive and impose sanctions when parties go against the grain. And if there's and this is probably a charge to Bisoye and to Madam Chair, who is my role model, mentor, and my mommy in this thing, that if there's anybody, any institution that can, sort of speak to the courts about implementing the Arbitration and Mediation Act properly, it's probably chartered institutes. So maybe it's one to start thinking about from our perspective as to how to train the judges on this particular point. And that's where I'll wrap up.
Thank you so much, Ifemena. Mary, let's have the perspectives from your jurisdiction. Is arbitration also seen as a first step in a lengthy litigation process? And what sorts of issues do you come across in set-aside proceedings post-arbitration?
Yeah, it's quite similar to the two contexts that have been put up, and I think what really is quite unfortunate, I can say unfortunate situation, is where in many times when an award has been given, I feel that sometimes counsel may rush through to really deciding or advising a client to get to a point of setting aside without counting their cards properly. Because I have seen that many times, most of the challenges in Zambia especially tend to want to use the route of challenging an award based on public policy. And now, our law and that principle, I'm sure that principle also, you probably have your own say about it, is that there are very limited grounds for challenging an award according to the law. And I think it's because the law has tried to protect the practice, of arbitration. And because also that also now comes back to an arbitrator where you really have to do your best to make sure that you render awards that are sound because of its finality. And you find that most of them are purely misguided applications to set aside, because I've not, no one has done a research. Maybe I should do that to just find out of all the cases that have gone for application to set aside, how many actually have managed. I can tell you for sure there are quite few. There are quite few. I think they can be counted. Most of the times the court have refused because counsel usually want to get, when they do those applications for setting aside, they tend to want to touch on merits which were decided in the arbitration. And this is where most of them fail. They fail to trace proper things that they can actually challenge an award for. They want to go into substantive issues that were decided in an award, at which the court will not entertain. I myself have had an arbitration challenged in court, and so one of the counsel in that case tried to actually go into the merits of the things that I decided in the case, and the court just couldn't entertain. And so this is where counsel needs to know. Please don't embarrass and waste your client's time and money by getting to include things that you shouldn't include in your application for setting aside. Of course, it's a right for you to set aside an award, but it should be a probable case because of procedural issues or what your law provides for. Because I think most of the cases that have ended up being challenged for me have been based on very wrong perception of what really the courts can decide on. And I just want to share something that recently has been happening here in Zambia. So this is now where a council decides to challenge a ruling of the arbitration tribunal. Yes, I know the faces. And the courts have made it. So this is one of the contract. It was an arbitration that happened, and it bordered on construction, of course. And so it really bordered on the issue I talked about, the timelines for submissions. So one party submitted documents which they were supposed to submit on the 3rd of March, and they submitted documents late. And the documents were couriered, and they only arrived on the 6th. Okay, and so the other party decided to challenge that they should have not been accepted because they were out of time. They should have applied for to file out of time. And so that went on, and the arbitrator had to rule on that and issued a ruling. And one arbitration council decides to go to court to have that ruling set aside. So there's so many things that are happening there. I just wish we can have researchers getting more interested to really get these things out and publish them, to just share that some of it, I think council needs to know and be aware. Arbitration is supposed to be cheap and cost effective. And some of the maneuvers that council tend to really engage in, they are against the client's interest. And I can only imagine that a client who's frustrated because you took them through or until the Supreme Court, you are just losing everything, would be a frustrated client, probably will never come back to you. So I think we need to do better. I will stop at that.
Thank you very much, Mary. It's interesting the particular scenario you've shared because I've come across something quite similar, where I, as counsel, had filed a pleading 9 minutes behind the deadline, and counsel to the other side took exception to it. Situations like this really, sadly, are some of the funny types of situations that you do come across in set-aside applications in court, and it ought not to be. I think counsel have a role to play to stop this sort of applications, as much as the courts do also have a role to play in making sure such applications do not fly. I'm looking at the chat box, and I do not see any questions, and so I presume and take it for granted that our speakers have done a fantastic job in delivering their points across. Please, the Q&A box is still open whilst we do a quick roundup. And so I'll just ask all the speakers, right, in 2 seconds, as quickly as you can. What do you think is the one thing parties, counsel, and arbitrators should have in mind, right? Pre-arbitration, during arbitration, post-arbitration, what should be that golden thread that all stakeholders should have in mind to ensure that they have a viable award at the end of the day? I'll start with you, Mitchell.
I think enforcement. From the minute you're briefed, you should start thinking of enforcement if you were to win. And you should start ensuring that everything is geared toward that. I think if you have enforcement at the back of your mind, every question that is faced, down to who's your arbitrator, down to whether or not you're going to consent to a request for extension of time for a counterparty to file their processes, it will inform every decision you make in respect thereof. So I'll say enforcement. From the minute you're instructed, start thinking enforcement.
Excellent. Mary?
I will say costs. Client's interest should be at the fore of it. The moment a client walks into your office and asks that, Effie, can you draft, we have this contract, can you help us review it? So when you sit down to look at the what they are suggesting, or what you sit down to draft an arbitration agreement, you should know that even the word "they" has a cost implication to the word applicable law has a cost implication, to the venue has a cost implication. The choice of arbitrator, number of arbitrators has a cost implication. So I tell people that drafting an arbitration agreement is not fashionable. It sounds so cozy. It's not fashionable. Every word in that agreement has a cost implication. And when you talk about cost implication, it goes to the root of the client's interest. Why did the client agree to you putting an arbitration agreement? Because probably you explain to them that it's efficient to resolve disputes through arbitration and it's cost effective. And hence, counsel should have that at the back of their mind. Thank you.
Excellent. Thank you so much, Mary. Ifemina, last words.
I think that Mary and Mitchell have taken all the good points. Because I was going to say Mitchell's zone and I was going to say Mary's zone. I think what I'm just going to say is, I think in considering things both from Mitchell and Mary's perspectives, I think it helps to understand the scope and extent of the applicable arbitration law, the procedural rules, and how that impacts your position if you are likely to be the winning party or the losing party. For example, if you look at Mitchell's perspective, you need to understand how the law helps you enforce your award when you get there, how the law helps you get around procedural obstacles. If you're likely to be the losing party, you need to think about the cost implication. I need to understand that under the AMA and under the procedural rules of the arbitration institution, for example, you could incur significant additional costs if your conduct is deemed to be, uncooperative and things like that. You need to understand that interest is discretionary, and if you choose to delay the arbitration award by fighting them in court, you could become incurring compound interest for years and years to come, and your clients could go bankrupt and could be wound up on the basis of just the compound interest alone. So I think just understanding the scope and extent of the arbitration legislation, the procedural rules, and in fact the laws, underlying laws, and your ethical obligations really um, plays a big role in how you can, deal with your arbitrations effectively and avoid procedural pitfalls. Thanks, Bray. Thanks, everyone.
Okay, thank you, Ifemina. I think that brings us to the end of our discussion. I would like to thank the panelists. It's been a pleasure working with every one of you. We would also like to thank the YMG chair, the chair of the Nigerian branch of the Chartered Institute, for the opportunity to make this presentation. It's been an honor and it's been a pleasure. I would hand over now to the chair of the YMG to give her thanks and to conclude. Thank you, everyone. Hello, Bisoy, are you there? Oh, I think she may be having network difficulties or she may have dropped off the call. I'm not particularly sure. Abisoye, can you hear us? Are you here?
Oh, yes, I can hear you. Well done. Well done, Gwega. So thank you for a very brilliant session. And I think we'll be handing over to Hada Isamadi. Hada, are you here to give the vote of thanks?
Wow.
Is it just me or I can't hear anything? Can
I
anyone
can't hear
else?
anything as well.
Okay,
I
okay.
think I saw her, but she must have dropped. It must be a network. Okay,
So
she's
she's
on.
online. She's just saying she needs to be on
Hello,
mute. Okay, she's there now. Thank you.
good afternoon, everyone. So a lot of people have already done the vote of thanks from the moderator to the YMG chair. So I'll just basically conclude by saying thank you to everyone that attended. It's out of your time, but it's also an opportunity for us to learn. And I'm sure we've learned a lot from the divergent speakers that we've had, from Mary to Mitchell to Ife. And of course, we will not forget our moderator that did an special job and ensured that, he navigated the conversation in a way that we'll be able to understand it and in a way that we'll be able to get out all the information we need. So thank you, Mr. Moderator. I will not finish this vote of thanks without thanking the YMG chair, Abisoye Fadahunsi. Thank you for the opportunity that you always give young members to be able to, expand their horizons and to also learn a lot in the arbitration space. And of course, the CI Nigeria branch chair. Thank you so much, man. You are an inspiration to everyone. You're a role model to a lot of people, and we thank you that you're giving the YMG wings to fly. And on this note, we bring this webinar to an end. Until next time we meet, ensure that what we've learned today, you use it during practice. Thank you so much, everyone.
Thank you very much. Truly grateful. Thank you.
Thank you. Bye.
Bye.
Bye, everyone.
Thank you. Bye-bye, everyone. Have a good day.